Thanks, Kate, and thanks for being with us this week. Welcome to our Tuesday webinar. I apologize to those of you who count on the energy boost from Bond's webinar intro music. Little technical glitch today, so I know I didn't hear it, so you probably didn't hear it, but we're still here. We're still working. So thanks for being with us. Let me just quickly jump into our agenda, and then we'll get things underway. If you could flip to the agenda, Kate, thanks. First off, we're going to have Caroline Westover with some news in terms of an EEOC focus recently. Then we're going to go downstate to New York City with our associate Liz Heifetz, who works in immigration, and talk a bit about I-9 compliance, a topic that always generates a lot of questions. So looking forward to that. Then we'll come back upstate to Syracuse to Nicole Macris, who's going to talk to us about a recent court decision about gun control. And then finally, Amber Lawyer here to talk about cybersecurity. So with that, let's jump right into it with Caroline. Go right ahead, Caroline. Thanks for being here today.
Okay, thanks, Kristen. Appreciate having you. Appreciate being part of the team today. So every now and then, I see a headline in our local newspaper that really piques my curiosity as a labor and employment attorney. And the headline that caught my eye late last week was the following: Central New York company hit with $1.6 million judgment for refusing to interview a deaf candidate. Since this subject matter is right in my wheelhouse, I thought it would be a good idea to continue on, and I read the article. So the case was brought by the United States Equal Employment Opportunity Commission, fondly known by most of us as the EEOC, against McLean Northeast. That's a distribution company with operations here in the Baldwinsville, Lysander, New York region of Central New York. This case was filed in federal court, specifically here in the Northern District, right across the street from our Bond Syracuse offices. And it focused on alleged violations of the Americans with Disabilities Act and Title I of the Civil Rights Act of 1991. Specifically in the complaint, the EEOC alleged that the employer engaged in unlawful employment practices when it refused to interview a deaf applicant back in 2018. The applicant had applied for 2 entry-level warehouse positions on 2 separate occasions, which basically these positions involved picking up product, putting it in totes or boxes, and then possibly using equipment, power equipment like a forklift, to move boxes to a docking or distribution area. The EEOC contended that the applicant met the minimum qualifications of the position, but yet when the company reached out to the applicant to do a phone screen, the company learned that the applicant was deaf or hearing impaired, and suddenly the HR representative rejected the candidate. Now, in all fairness here, we weren't part of that matter. We weren't in the courtrooms when the trial proceeding was going on. So this is really just a high-level summary of what the basic facts were. So the EEOC argued in this trial that the company's failure to interview, consider, and hire a qualified applicant solely because the applicant was deaf was intentional and willful. So again, why does all this matter? Well, after a 3.5-day jury trial, it only took a 7-person jury 2 hours to find that the company had violated federal law. And they also concluded, 1, the individual was a qualified individual with a disability. 2, that the company had discriminated against the applicant by failing to give her an opportunity to interview, and then by failing to actually hire her for one of these 2 entry-level positions. And 3, that the applicant had suffered significant damages as a direct result of the disability discrimination. So what's the end result? Well, the end result was a damage award in the amount of $1.675 million, which is not an inconsequential amount here in upstate New York by any stretch of the imagination. When you break it down, it was $25,000 of back pay, $150,000 of emotional distress damages, and this is the kicker, as we've often told our clients, $1.5 million in punitive damages because the act was intentional, or at least that's what the jury found. So in all fairness, like I said, this one hit a little close to home because it was right in our backyard. But the McLean Northeast decision is not the only recent case where the EEOC has pursued litigation against an employer for failure to hire deaf applicants or consider them as qualified applicants for various positions. Last month, in January 2024, the EEOC won a jury trial against a trucking company in Nebraska for the same thing, refusing to hire a qualified individual who had a hearing impairment. In that case, it was an 8-person jury, but again, they found that the company had violated the ADA by failing to hire this person who was otherwise qualified simply because he was deaf. In that case, compensatory damages $75,000, $36,000 in back pay, roughly. But here was the other key piece. That jury awarded $36 million in punitive damages. Clearly a lot more than what was awarded here in Central New York. Now, due to some technical statutory limits, that $36 million was decreased to $300,000, but nevertheless, we're talking about large sums of money for employers who are not necessarily reminding or considering the ADA qualifications and how to properly assess applicants with disabilities, in this case, hearing disabilities, as part of the hiring process. So in addition, in that case, the EEOC also got the judge to issue a court order that that company in that Nebraska case has to comply and submit semi-annual reports to the EEOC for the next 3 years about what its hiring data looks like and applicants, particularly for deaf individuals. And then finally, just one other case, we started to notice a little bit of a trend here with the EEOC really taking an aggressive approach towards failure to hire cases when we're talking about hearing impaired individuals. In the fall 2023, the EEOC also just initiated a lawsuit, so we'll keep an eye on this one, out in Chicago, again, for an employer who refused to hire a qualified deaf applicant for a mail handler position. And according to the EEOC, the employer had rejected the applicant based on a faulty assumption that deaf individuals cannot work safely in a warehouse setting. So what's the takeaway from all of this? Well, there's just 3 things that we thought might be helpful to employers as you kick off hiring season or as you're starting a new year. Make sure your HR folks are properly reminded to consider all applicants that come in. The EEOC, through all these litigations, has sent us a clear message that they will not tolerate discrimination against deaf or hearing impaired applicants, that they need to be given a fair opportunity and fair consideration to apply for positions. And certainly that not only goes for hearing impaired individuals, but any qualified individual with a disability. Second, employers cannot and should not make hiring decisions based on assumptions or stereotypes about what certain individuals can or can't do, or what individual work environments may or may not be safe for individuals. You have to go through that analysis. And then finally, we all know, but it's a good reminder for everybody here, that the ADA requires an individualized assessment about whether reasonable accommodations may be available for a particular position and whether they need to be provided, what an individual candidate's capabilities are. And so don't assume that what may work in one case or what you did in one circumstance would work again. So really the takeaway, keep an eye on what you're doing. Make sure that you are speaking to and interviewing qualified candidates, because the EEOC is certainly watching. Okay, Kristen, back to you.
Thanks, Caroline. Almost didn't have my voice there for a second, but there it is. Thanks, Caroline, for that update. Great reminder. Certainly this is all in the hiring context as we were discussing, but it just brings to mind to me, conversations I've had with clients in other contexts, such as, we have a lot of healthcare clients that attend this webinar, and, definitely gotten questions about obligations for, interpreters when you encounter deaf patients. So good to take a sort of a broad inventory of those issues, depending on what industry you're in. So not only hiring, but perhaps other types of accommodations. And perhaps a topic for a future webinar, now that I say that. But thank you again. So next on our agenda here today is Liz Heifetz from our New York City office. As I mentioned, question number 1, Liz, is it currently snowing in New York?
It is a lot less now than before, but nothing compared to upstate New York, I can imagine. For us, 2 inches is madness, chaos, havoc in the streets, but it is beautiful. I love it. This is why I'm in the office, because I love the snow, and it is snowing. That's
well, we've got blue skies in Syracuse, so it's like backwards world today, but good luck with that snow. But thanks for being here with us. And let us, why don't you just go ahead and give us what you have today in terms of I-9 updates.
All right. So I just wanted to touch base on a couple of things that we've been seeing with regards to I-9 compliance, what you should look out for, suggestions, recommendations. Some of this would be a lot of reiterations of things you probably already know, but just to know what kind of, to expect to do, moving forward. So, I mean, this first part, as you probably already know, there's a new I-9 form that has gone into effect that should have been used as of November 1st, 2023. So if you haven't started using it by chance, you're onboarding new people, make sure to use this new form. The forms are incredibly similar. I've, included a list of the changes that you'll see. They're very minimal, but the DHS will be a stickler for this. So just make sure to be using this new form, just kind of as a basis. Kate, can we go to the next slide, please? So for here, I wanted to talk a little bit about this alternative procedure E-Verify situation. This was come out, pre-COVID, during COVID, after COVID. I just wanted to reiterate it again because we are seeing it pop up with questions. For those that don't know, like the main takeaway from this is that it is optional. I mean, you do not have to do it. You can offer it. It must be consistent in the place you are hiring. So even if your headquarters is in California, but you're hiring in New York, every employee that is being onboarded in New York has to be allowed to go through this process. You can choose to do this for remote employers, but you also may consider, continuing doing the physical inspection on site and do it for hybrid, but just maintaining consistency will be super, super important. And also, with respect to fairness, there will be some people that are unwilling to submit things, through this alternative procedure system, and you should still make accommodations for that as an employer. The actual E-Verify alternative procedure I listed below. You just have to make sure to, as I'm sure all of you already know, that the documents must appear genuine, be very specific. DHS is honing down on that. We've seen several audits come through. I've worked on one recently, actually, where the employer did not realize that what they were looking at wasn't genuine. They thought, this is a green card, this is a driver's license, everything seems to be in order. Be very meticulous with the documents you are looking at. Your employer will present you documents, complete the I-9 in a lot of depth. We'll, go through that in a couple of slides from now. Make sure that the examination is completely complete, and obviously retain a clear copy of the documents. You should be keeping these documents for at least 3 years after any employee terminate his or her employment, or he or she resigns. So make sure to keep that also on file for at least 3 years. We'll go to the next slide, Kate. Here, I wanted to focus a little bit about this remote work situation implications, because, since COVID, this has become much more of a thing that has been happening. And just to reiterate on a couple little things that are popping up on I-9s. So one of the questions that pops up is the distinction between verification location and the hiring site. So on the I-9 forms, the verification location is where the employer actually takes the information from the employer and registers them into E-Verify and creates the case. The hiring site is where that employee is actually hired. Those 2 locations could very well be the same, but they could also be different. And it is important to accurately note that on the I-9. So, for instance, I'm in New York and I'm verifying an employee. Here I'm physically holding the documents here and checking off, okay, and creating the case, but my subsidiary is somewhere in Massachusetts. The hiring site is Massachusetts. If for some reason that employee is remote and working from, the Midwest or something like that, the hiring site will actually be New York as well, because I'm hiring them from the same place where I'm filling out their information. So just note that distinction when you kind of go through the I-9 process. If you have any questions, obviously feel free to reach out. We'll confirm, but this is just something to keep in mind in this new remote world that we live in. For those who have gone remote fully and those who are doing it on a hybrid model. Kate, can we go to the next slide? So with respect to audits, this is going to be a thing that I suspect employers will care very much about. We have seen penalties rise, as stated here, over $2,000 for each defective form. It's very important to understand the difference between, substantive procedural violations, because sometimes you may think that a tiny little error, I forget to put an NA in a blank or something to that effect, can rise to the level of procedural violation. But even more so than that, if depending on that specific technical area, it could actually very well be substantive. Substantive errors, as it is defined, cannot be corrected as a result of the error and omission. This can be anything from, failing to produce an I-9, an employee's name is missing, an employee's name doesn't match the physical green card document, for instance, signature is missing, or the signature's on the wrong page. A lot of these could seem paper violations, but they're not. They're much more substantive, and the DHS very, very much cares about this. Something to keep in mind here too, if your company is going through an acquisition or merger of sorts, and you're bringing on another company with its employees who you presume have already gone through their own, valid, good faith onboarding process, you should not assume that has happened. There should be some system in play for being able to confirm that those employees that were previously employed by this company that you acquired, that are they're authorized to work. So if you need to kind of revisit their documents, re-request it, that should happen, just because if an audit is issued, you should be able to show those documents. And having a merger and acquisition is not an excuse to not have that. And that has happened recently in an audit that I have seen. So it's just, you need to be able to kind of justify that in many respects. Procedural, as I mentioned, procedural and technical errors are just minor, violations that ICE will allow you to correct. And they usually give you about 10 business days to correct them. You should, be very responsive with them. They do allow a lot of leniency sometimes if you're very responsive to their request. And provide them with more than enough information. They very, very much request that. I've seen that we were able to negotiate down an $80,000 fine not too long ago to something that was $10,000. So it is very doable. These examples can just include something, forgetting to label a document title, something that shows that you did not knowingly hire someone, but there was something that just might have been accidentally overlooked. There's a fine line between these two, but it is something that we can advise if you let us know if you have any questions as you're filling this out. And obviously anything in bad faith will be automatically considered substantive. Anything that is initially procedural will rise to the level of substantive if it was done in bad faith. And you cannot use the excuse of we were relying on the good faith provision in order to do this. And then, it won't fly with them. You just have to, the bottom line with these audits is showing that you did not knowingly do something illegal. You did not knowingly hire unauthorized people. And so you have to show due diligence with respect to that. If an audit is received, and a lot of these can be random, I've outlined, this little chart of how the actual audit system, works, what the structure of it is. You should request a hearing, and you should absolutely attempt to negotiate it down, because it will be in the employer's interest to do so. The Office of the Administrative Hearings Officer doesn't use this matrix model. One of the main reasons is because it lowers the fine assessment. It gives weight to the employer's ability to pay. You just should be very mindful that options are available, and we'll walk you through the specific details of that should it come up. But just know that absolutely you should always request a hearing. If you need more time, take it. If you need to negotiate, write to the opposing counsel. It absolutely should be done, because you will be able to get the fines down significantly if you do so. And lastly, Kate, if you can go to the last slide, please. I just wanted to hone in a couple things that are happening that that should be doing. So if you haven't already enrolled in E-Verify, you should absolutely do so. With E-Verify, what we have seen in case of an audit, for instance, if for some reason companies did not have the documents for an employee that was terminated a couple of years ago, but there is a solid E-Verify record of that individual with the dates and the documents that were provided, it may not completely eliminate, the burden of having to show the documents, but it significantly can work when it comes to negotiations and, bringing down the fine that you have been given. DHS very much appreciates E-Verify records that are very on point. And I would just make sure that if you do enroll in E-Verify, you make sure those records are diligent and the dates match. So if you have documents that don't match E-Verify, for instance, that could be problematic. But as long as you have the records and you don't have the documents, not ideal, but better than nothing. So do enroll in E-Verify. And the last thing is this image system. I don't know how many of you have heard about it, but this is another big thing that DHS is implementing. This came out, I think, in 2006 as a partnership between ICE and the business community. It's a free program for employers to enroll in, free to leave without any adverse actions. This program is essentially, it provides business protection from administrative I-9 audits. It provides training and assessments for completion of I-9s, without having businesses to pay for it on its own. When you go through doing this, you avoid the risk of, random audits that could happen without this. It's essentially, we can, if this is something that you would like to enroll in, this is something we can work with you to do it. It essentially, this is a kind of like a reminder or a reassurance for a DHS if the company is enrolled in the system, that is kind of, and so to speak, it's kind of more trustworthy for them. If they see an employer is part of the image system, they will refrain from putting this much pressure as they would without it. So this is something absolutely to consider. Obviously, if you already have a criminal or administrative action pending, you can't join this quite yet, but there's ways to get through that. So just a couple of things, reminders, suggestions, keep in mind. Feel free to let me know if you have any questions. I-9 compliance is always, a forefront thing in everyone's mind. So let me know if there's anything else. With that, Kristen, I'll just leave this back to you.
Okay, thanks so much. I mentioned at the beginning that we always get a lot of questions with I-9 presentations, and today was no exception. So a couple things. A few of you have asked for a copy of the presentation. Just so all of you know, following today's webinar, we do post a link to this recording as well as a separate link to the slides on our website. So just go to the website under, I believe it's under events, and there is a archive of all of this. So you can definitely go there and take a closer look at that chart, which I know if you're like me, we'll probably need to zoom in on a little bit to see. A lot of good information there. There was just a question, Liz, if you could clarify retention of how long need to retain, whether it's related to the date of hire or the date of separation. And Caroline, I know you're an immigration lawyer as well. One of you wants to just weigh in on that?
Yes. So, and Caroline, feel free to jump in as well. It's 3. Usually we tell everyone 3 years. You should keep it for 3 years from the last day of employment of that particular employee. You should keep those records on file for 3 years. That's kind of the short version of that answer.
Okay, great. Couple other questions in the chat, just to keep us moving along here. We'll try to get to those. We always do try to get to them. If we don't get to yours, we'll try to follow up later. But thank you for your questions. Thank you, Liz, for your presentation. A lot there to think about. So moving on to our next topic. This is a topic that we have talked about before, but it's been a while on this webinar. New York passed a new gun control law. Maybe Nicole, quite a while ago, but has been subject to a whole lot of litigation and a whole lot of challenge. And so today Nicole's going to tell us about the latest update on that and what happened with the Second Circuit just I think a month or two ago. So Liz, thank you. I'm sorry, Nicole, thank you. Nicole is an associate here in our Syracuse office in our litigation department. So with that, I will turn it over to you, Liz. Oh, Nicole, sorry.
Sorry. Okay, Kristen. Thank you. I'm here today, as Kristen said, to discuss the Second Circuit decision in a recent consolidated appeal that addresses the Concealed Carry Improvement Act in New York State. This is commonly referred to as the CCIA, and that is how I will refer to it. By way of background, following the landmark Bruin decision from the Supreme Court of the United States, New York enacted the CCIA, and that was in July of 2022. So fairly recently, but not too recent. So as relevant to today's discussion, the CCIA in part amends the penal law to first require applicants to have good moral character in order to obtain either in-home and concealed carry license. And it also requires them to disclose specific information. Second, to make it a crime to carry firearms in 20 designated quote unquote sensitive locations, regardless of whether or not you have a concealed carry license. And the third is to make it a crime to possess firearms in restricted locations unless given affirmative consent to enter with your firearms. So the consolidated appeal before the Second Circuit addressed these amendments that the CCIA made to the penal law. In summary, the district courts enjoined the following provisions of the CCIA. First, the part of the licensing requirements that require an applicant to have the good moral character, and that an applicant disclose to a licensing officer a list of the applicant's current spouse and all adult cohabitants, and all former current social media accounts within the last 3 years, and a catch-all phrase of any other information that an officer requires. So as to the sensitive location provisions, the preliminary injunction was for the provisions that prohibit carrying firearms in locations providing behavioral health, chemical dependence care and services, places of worship, public parks and zoos, buses and airports, places licensed for alcohol consumption on site, theaters, conference centers, banquet halls, and also gatherings where individuals are expressing their constitutional rights to protest and or assemble. And the final provision is the restricted location provisions. So the Second Circuit affirmed the injunctions in part, vacated the injunctions in part, and further remanded the matters for proceedings consistent with its opinion. So specifically, the Second Circuit upheld the injunctions as to the social media disclosure and restricted properties as applied to the private property held open to the general public and as applied to Pastor Spencer and Tabernacle Family Church, its members, or their agents and licenses. So the scope is pretty narrow as to 2 of the 3 injunctions. And the injunctions that were vacated are the remaining injunctions. So those had to do with the plaintiff not having standing to challenge the law, so a pretty fundamental procedural ground, or on a finding that the laws challenged don't have or did not facially violate the Constitution. So I do want to highlight here that the procedural posture is at a very early stage in litigation. The court did not make a determination on the merits of the case, which is on the constitutionality of the CCIA. So rather here, the court reviewed the district court's decision in granting preliminary injunctions. So the standard is whether there's a likelihood of success on the merits. So it's a pretty early stage, and we will keep you updated as the parties continue to litigate these cases. Thank you. Back to you, Kristen.
Great, thank you. So let me ask you this. If you take a look at what is considered a sensitive location, it's a lot of our clients here. So we're talking about colleges, universities, just looking at the list right now, theaters, stadiums, libraries, places of worship.
Right.
Are those, so as of today, knowing that it's early in the litigation, as of today, the law still stands with respect to that concept of sensitive locations, correct?
Correct.
Okay.
Correct.
Case has been done, but for right now, for example, we have colleges on the line. still against the law to carry a weapon in those locations, correct?
So the only injunction that remains with respect to a more general population would be the restricted properties as applied to private property held open to the general public. Now, I'm not entirely sure whether that is pretty narrow or not, but we can definitely follow up and get our clients that information if they would like.
Okay, great. Yeah, I mean, definitely an interesting case. These prohibitions on carrying weapons is very broad. I mean, I didn't mention bars and restaurants that serve alcohol, right? A lot of those around.
Right.
So, we will continue to look at this and update our clients, perhaps get something up on our website. But thanks for that update. And interestingly, this case originated in Central New York. So kind of some local names on the caption here in Syracuse, but certainly applies across the state. So great. Thank you so much, Nicole. I got the name right there.
You're welcome. Thank
All right. So moving on to our final presentation, last but not least, Amber, lawyer who is co-chair of our cybersecurity practice group. Amber, isn't it like a special month right now? Is it Data Privacy Month or something like that?
Yeah, thanks, Kristen. That was last month, but we wrapped it up at the very end of the month, and we're still putting out some relevant publications and materials. So a great highlight. That actually will go right into my first slide here.
All right. Well, I was so excited about it. I wanted to continue it along. So okay.
I appreciate it. I appreciate it. Thanks,
right.
Kristen.
Yep.
So the firm every year in January does this event. We call it Countdown to Data Privacy Day. And Data Privacy Day is a globally recognized holiday, especially in our cybersecurity and data privacy group, where we try to feed information to our clients on relevant updates in the data privacy world, if we're seeing changes in law and kind of emerging issues that arise. So in the month of January, we actually put out quite a few articles in relation to data privacy. And so I've listed them here. Those are all on our cybersecurity and data privacy website for folks to go check out. Feel free to review them. There's quite a bit about artificial intelligence, expanding the scope of privacy law, and how we're dealing with cybersecurity insurance, increased requirements, some comments on international privacy law, including India, and then something I'm going to talk about today, which is New Jersey becoming the 13th state to enact a general consumer data privacy law. The other chair of our privacy group, Jessica Copeland, also just did a fantastic podcast interview with Kim Wolf-Price. And our podcast talks quite a bit about artificial intelligence. So AI, emerging issues with AI, what we're seeing there, things to look out for, ethical considerations, biases, and just kind of developing technology in the AI sphere. So I wanted to kick off kind of with a recap of Countdown to Data Privacy Day, just because like Kristen, it's kind of like Kristen said, we continue on even though the day was January 28th. If anyone has questions about that, feel free to put them in the chat and I can follow up. Okay, next slide, please. So I always like to start with a general update on where we are in the United States on data privacy legislation. This chart comes from the International Association of Privacy Professionals. They do a pretty good job of keeping track of all the privacy legislation we have in the United States. And I want to note, this map highlights just general consumer data privacy laws. And so what you can see here is there's quite a bit of green and quite a bit of blue. And that's a huge change. So our first data privacy law came into effect in 2018. It was California. California was the only state, and it took a little while for states to catch up, but here we are today. We now have 13 states that have enacted privacy legislation. We have a whole host that have pending privacy legislation. Last year, we had federal privacy legislation that did not pass, but was proposed and went as far as we've ever seen. And so really a hot button topic for businesses in all areas to consider. Okay, next slide, please. All right, so here's the list of enacted general consumer privacy laws, a little bit easier to read than the chart. We had California, which passed in 2018, became effective in 2020, and was then amended again in 2023. We have Colorado, Connecticut, Delaware, Indiana, Iowa, Montana, New Jersey just joined the group, Oregon, Tennessee, Texas, Utah, and Virginia. One important note while I'm on this slide, just a general update about California. Actually, on February 9th, we had a decision issued out of California in relation to pending regulation enforcement. So the California Consumer Privacy Act, which was amended by the California Privacy Rights Act and became effective in 2023 on January 1, had rules pending regulations that were supposed to become effective and enforceable on July 1 of last year. Litigation was started because the rules were not issued by the privacy agency out of California in the appropriate time frame, according to the litigants. And so there was a lawsuit filed to delay enforcement of those regulations until a year from the issuance of the regulations. On February 9th, the appeals court actually decided that those rules and regulations are currently enforceable. So all of the amendments and regulations that came out last year for CPRA are now currently enforceable, and there is no delay. And that's the current status of that litigation. So I wanted to alert folks to that who may not know. That's hot off the press. We'll be putting an information memo out about that here in the next day or two. Okay, next slide, please. All right, let's talk about the New Jersey General Consumer Privacy Law for a second. So New Jersey just passed this law. It will not become effective until January 15th, 2025. So you have a window, quite a good ramp up window to comply here, to get into compliance. What is this law? It's a law that applies to entities that collect and process the personal information of New Jersey consumers. A consumer is a resident of New Jersey, and it applies to entities that are processing the personal data of at least 100,000 consumers, excluding if you're only processing their data for payment transactions, or if you're processing the data of 25,000 consumers and you're deriving a revenue from selling their information. So if you're selling the information of consumers, you're creating any kind of revenue from that sale, the threshold lowers. It's important to note, if you're familiar with other consumer data privacy laws, there is no revenue threshold here. So Colorado, Texas, have this same setup, but most laws like California, Virginia, etc., have a high dollar threshold where you're basically pulled into the law if your entity collects $1 million in gross annual revenue, or $10 million. So there is no revenue threshold here. That's helpful for entities that may not otherwise be pulled into the law. But important to note that if you're processing the information of consumers from New Jersey, you need to do an assessment about whether or not you would be subject to this general consumer privacy law. There are some very notable differences in the New Jersey consumer privacy law as opposed to some of the other states we're seeing. The first is that sensitive information pursuant to the law will include financial account information. And I'm not just talking about bank account number, credit card number, debit card number, talking about even the information to log in. So a user's name, account login and password, security questions, things like that will be included in the definition of sensitive information. Why does that matter? You have to treat that information with a higher standard of protection. You have more compliance obligations. There is an outright prohibition on processing the data of children between the ages of 13 and 17 without proper consent. What does this mean? If you're marketing to children, if you're potentially collecting information from children within this age group, we need to ensure that you're obtaining proper parental consent, you're allowing for proper opt-out before processing of this information. Probably the most notable exception in this privacy law, as opposed to many of our other states, is that it is applicable to nonprofit organizations and institutions of higher education. There is no FERPA exemption currently written into the New Jersey Data Privacy Act. That is rare. Every other consumer privacy law exempts the processing of information that's subject to FERPA. We do not have that exemption here. And so it's important to note that if you're a nonprofit institution or a higher ed institution and you meet these other thresholds, you will be subject to the law. There is no outright exemption. Okay, next slide, please. So what does a consumer data privacy law actually do? Many of you have probably heard of this, but it affords rights to consumers in relation to processing their information. So now I'm sure you're all familiar because you've seen the privacy policy updates that keep coming into your email. These consumers from New Jersey will have rights in relation to their information. So if you're a nonprofit institution that solicits donations from consumers in New Jersey, or you're a higher ed institution that collects applicants from New Jersey, you now likely, if you're subject to the law, have to establish mechanisms for consumers to submit rights requests. And those requests include everything I have listed on here: that the consumer can access their information, correct their information, ask you to delete them from a marketing list, et cetera, and rights to opt out of certain targeted advertising. These rights are afforded to consumers basically to allow them to have more control over their personal information. Now, most clients that I talk with panic at the point of hearing, what do you mean a consumer can tell me they want to delete all of their information and I have to comply? That's not necessarily true. There are exceptions to every single one of these consumer rights requests. If you have to maintain certain information pursuant to law, if you have to retain certain information to perform a contract or a transaction with the consumer, there are exceptions to each one of these, but it's important to know. In relation to these rights, one of the obligations that every entity that's subject to a privacy law has to comply with is to provide adequate notices. How do we do that? We handle that in privacy policies, in pop-ups. So everyone sees those cookie pop-ups now that says the website is using cookies, obtaining consent if necessary. So if you're collecting information for text messaging, or if you're collecting any of that sensitive information or information from children. And so what I always like to tell clients is it's important to do an assessment of whether or not you're subject to this law, if you're subject to any other jurisdictions, and then your low-hanging fruit, your action item is to start working on your privacy notices, right? We need to inform consumers of the data we're collecting, why we're collecting it, where we're sending it. And the best way to mitigate risk in relation to these laws is to have proper notices upon collection of the information from those individuals. Okay, next slide, please. Just want to talk briefly about other emerging issues. I mean, I could go on for probably a full hour on artificial intelligence and everything we're seeing there, but I know the last time I did this presentation, there were several questions about sector-specific, data-specific, or technology-specific privacy and cybersecurity laws. So I just wanted to highlight a couple of those today. We are seeing changes in sector-specific laws. So if your entity is currently subject to a HIPAA, a high-tech, a privacy law that is specific to your sector, we are seeing changes in those laws to require new cybersecurity safeguards or new privacy safeguards. Quick example I threw on the slide here is last year, the Gramm-Leach-Bliley Act was amended to include an updated rule called the Safeguards Rule, which mandates certain cybersecurity safeguards if your institution is collecting information that's subject to the law. The Safeguards Rule also really expanded the scope of what information was protected. And so entities from auto dealers to higher ed institutions, to, of course, financial institutions and lending institutions were all pulled into this new update. And the update requires things like multi-factor authentication, a written information security program, and many cybersecurity requirements. Those became effective last June. We have a ton of clients that are still working through how to have proper policies, procedures, et cetera, et cetera. We saw the same updates for New York State DFS. Two more updates, and then I'll turn it back over to Kristen. In tech-specific law, we are seeing a huge uptick in litigation for monitoring. So if you're doing any kind of electronic monitoring of employees or any kind of monitoring or recording of individuals, third parties who are hitting your websites or when they're calling in, there's a huge uptick in litigation, in state litigation in relation to that. And so be aware that there are quite a few changes coming from a litigation standpoint. And the way to mitigate risk there, again, is proper notices. Of course, we're seeing a huge change in the AI world as well, pending regulation, pending law, and we have some automated decision-making laws coming out in California, in New York City, et cetera, et cetera. We have developing biometric privacy laws, and then we have some expansion in the rights related to children's privacy. And so I will wrap it up there. If anyone has any questions, feel free to ping me. Kristen, I'll turn it back to you.
Great. Thanks, Amber. Always a wealth of information about that area of law that I find completely fascinating, but a little bit overwhelming. So glad that we have you guys working on that for us. So thanks. The screen right now, we've got all the email addresses of our presenters. They're happy to take any follow-up questions. Please do reach out. We always appreciate your attendance at this webinar, and I'll see you again in 2 weeks. Take care.